To start the arbitration ball rolling, Asianix's counsel files a notice of arbitration on 5th December 2013 at SIAC, along with an application for emergency interim relief, requesting SIAC to appoint an emergency arbitrator. They have also sought an injunction against Electro Oceania's invocation of the bank guarantee. Asianix's counsel have also paid SIAC's filing fee and the emergency arbitrator administrative fee. SIAC has considered the request, and within 24 hours, the president of the SIAC Court of Arbitration has appointed a senior Singaporean arbitrator as the emergency arbitrator. Via teleconference with all parties, the emergency arbitrator immediately sets out a schedule for submissions relating to Asianix's application for emergency interim relief, and schedules a hearing on 12th December 2013. Parties indicate that they will be represented by Singapore counsel at that hearing, and that necessary arrangements will be made for the hearing to be conducted at Maxwell Chambers in Singapore. All of this took place within 1 week of Asianix filing its application for emergency relief. Let's now join them for the emergency arbitrator hearing.
Good evening, everyone. I propose we begin with Claimants' Counsel, followed by Respondents' Counsel.
Thank you. Mr. Emergency Arbitrator, I believe the issue at hand is fairly straightforward. My client, Asianix, entered into supply agreement with the respondents for the supply of components for a thermal power plant, which the respondents were building in Zurasia. The supply agreement required my client to provide a performance guarantee for 10% of the total value of the contract. The total contract value is $120 million US. 10% of that is 12 million. The bank guarantees took the form of two separate bank guarantees, each for $6 million, and both were drawn on LBS Bank, New Delhi, India. My client duly complied with that requirement, provided the bank guarantees. And the details are in the papers before you. The contract provides that the respondent shall be entitled to invoke the bank guarantee in the event of, inter alia, a material breach of the contract by my client. Clause 4.5 of the contract states, the employer and confirming party shall not make a claim under the performance security, irrespective of its terms, except for amounts to which the employer is entitled under the contract in the event of A. Failure by the contractor to extend the performance security as described in the preceding paragraph, in which event the employer may claim the full amount of performance security. B. Failure by the contractor to pay the employer an amount due, as either agreed by the contractor or determined under Subclass 2.5, which deals with employer's claims, or Clause 20, within 42 days after this agreement or determination. C. Failure by the contractor to remedy a default within 42 days after receiving the employer's notice, requiring the default to be remedied. Or, and so to us this is the one that matters, Subclass D, circumstances which entitle or would entitle the employer to termination under Subclass 15.2, irrespective of whether notice of termination has been made. So, Mr. Emergency Arbitrator, we go to Clause 15.2 that deals with termination, and we say the clause only permits the employer, in this case the respondent, to terminate the contract in the event of a material breach of contract. Clause 15.2 states, the employer may be entitled to terminate the contract if the supplier, A, fails to comply with subclause 4.5, which has to do with performance security, or with a notice under subclause 15.1. B. Demonstrates the intention not to continue performance of his obligations under the contract. C. Without reasonable excuse, fails to supply materials in accordance with clause 8. D. Assigns the contract or subcontracts the works without the required consent. E. Commits a material breach of the contract. Or F. Becomes bankrupt or insolvent or goes into liquidation. Mr. Emergency Arbitrator, our point is that the bank guarantees before you are not on-demand guarantees. The respondents are not entitled to invoke the bank guarantees without first establishing before a duly constituted tribunal that the respondent was entitled to terminate the contract. Without this, any invocation of the bank guarantees is premature and is illegal. At this point in time, the respondents have submitted no document identifying the provisions of the contract under which the respondents claim that they have the right to invoke the bank guarantee. Given this, it is clear they are not entitled to do so. I would draw the emergency arbitrator's attention to the fact that neither the contract nor the issue of whether the respondents are entitled to invoke the bank guarantee are governed either by Indian law or the law of Oceania. We submit that this arbitration is seated in Singapore. The applicable procedural law is the law of Singapore. In this instance, it would be Chapter 143A of the International Arbitration Act. Concerning the law relating to the question of preventing a call on a guarantee, the courts in Oceania, India, and Singapore are consistent in their view that courts should be slow to interfere with the rights of beneficiaries under an unconditional on-demand bank guarantee. This is unless fraud is involved or where encashment of the bank guarantee creates irretrievable harm or injustice to one of the parties, or when the invocation is contrary to the terms of the guarantee. Singapore is slightly different from the other two in that Singapore has disavowed the ground of unconscionability as a ground to found the ground of an injunction to prevent a call on a performance guarantee. But in this case, we are not dealing with an unconditional on-demand guarantee. And so the law in relation to when the general defenses against such an invocation, that does not apply to our case. In finishing, can I point out there is an urgency to this matter. The respondents are highly likely to call on the bank guarantee, particularly since the Zurasia contract has now been terminated. We submit the claimant has a good prima facie case under the supply agreement and that the respondent will not suffer any serious harm should the bank guarantee not be invoked at this stage. Thank you.
Thank you. That was very useful. I now invite the Respondents' Counsel to make your submissions.
Thank you. With all due respect, I believe the claimant has completely missed the point here. The simple fact of the matter is that the parties entered into a contract for the supply of goods. The contract required the claimant to provide us with a guarantee to keep us secure from any defects in the quality of the goods supplied. The claimant then proceeded to supply us defective goods, clearly breaching the guarantee. We are therefore entitled to exercise our contractual right to invoke this guarantee. It is also important to note that the respondents have informed the claimant of the defects in the components that were required for the power plant. The claimant has not taken any steps whatsoever to remedy these defects. This fully entitles the respondents to not only invoke the bank guarantee but also to terminate the supply contract itself. Since the bank guarantee has been issued by the LBS Bank in New Delhi, we would respectfully argue that Indian law is clearly relevant to the question of its invocation. Invariably, Indian courts would not grant any injunction restraining a call on an irrevocable, unconditional bank guarantee. The authorities on this point are already before you, sir. The only recognized exceptions are if there's evidence of fraud, of which the beneficiary seeks to take advantage, or where allowing the encashment would result in irretrievable harm or injustice to one of the parties concerned. In some of these cases, cases much like our own, the bank guarantee provided that it shall not be open to the guarantor to know the reasons or to investigate the merits of the demand invoking the bank guarantee. This is very important. Further, there is no urgency, whatsoever in this case, since the monetary award can adequately compensate the claimant in the event that the respondent's invocation of the bank guarantee is subsequently found to be wrongful. In other words, there is no urgency simply because there is no harm to the claimant whatsoever. With this, I have no further submissions to make, sir, but I'm happy to assist the emergency arbitrator if required to.
Thank you, Respondents' Counsel. That clarified the position. I have one question to Claimants' Counsel. Assuming for the sake of argument that I'm with you, would the claimants be agreeable to providing an undertaking to indemnify the respondents from any loss in the event that ultimately the respondent is entitled to invoke the bank guarantee?
Mr. Emergency Arbitrator, the claimant would certainly be willing to provide such an undertaking.
Good. I do also note that the bank guarantee is only due to expire in December 2015. So I would assume that the claimant would have no objection to maintaining the validity of the bank guarantee until the end of its natural life.
We would not alter the validity of the bank guarantees until the completion of the arbitration.
Thank you. If there are no further points to be made by either counsel, I intend to bring this hearing to a close.
My apologies, Mr. Emergency Arbitrator. We have one further point to make. This is in response to the respondent's point that the claimant has not made any effort to rectify the defects which the respondents claim.
Proceed.
Mr. Emergency Arbitrator, subsequent to the cancellation of the contract between Zurasia and the respondents have refused to accept shipment of the goods which were supposed to be part of Phase 2. And this means that the claimant's personnel have been denied entrance to the project site by the respondents. More recently, the new military government of Zurasia has cancelled the employment permits of all non-Zurasian personnel. Therefore, the claimants have not been in a position to rectify the defects at date. I should point out, the respondents have failed to provide any true idea of the defects upon which the respondent's counterclaim relies. The respondent has merely stated that there are defects. Mr. Emergency Arbitrator, the dispute as it now appears would likely involve determination of difficult questions of fact and the interpretation of the contract. None of these things can be done at this stage of the arbitration process. I would submit that applying the real probability test, my client passes that threshold test that there is a strong arguable case on the merits in favor of my client should this matter proceed to a full hearing. Thank you.
Your points are duly noted. I will write to both parties if I require any further clarification. Otherwise, thank you everyone for your attendance and for your assistance, and have a good evening.
Thank you.
Thank you, sir. Thanks. Thank you.
With that, the emergency arbitrator completes his hearing. He then drafts an award on the application for interim relief and submits it to SIAC for scrutiny. Since it is an emergency, SIAC scrutinizes and responds the very same day. The emergency arbitrator then signs the award and returns the signed copies to SIAC for transmission to the various parties. In this case, the emergency arbitrator has issued a reasoned decision, finding ultimately that the respondents are not entitled to invoke the bank guarantee until final determination of the dispute by a tribunal. Asianix is understandably relieved.